which allows the UN to take necessary actions to fulfill its duties, even if not explicitly stated in the Charter. As of September 19, 2024, it was reported that Israeli authorities stopped issuing visas to heads and staff of the international NGO community. As the UNRWA Commissioner General has underlined, quote, "The government of Israel has been phasing out representation from humanitarian organizations or those engaged in reporting on the atrocities of this war and the impact on civilians. As humanitarian needs to continue to increase, we need more humanitarian workers, not less. The opposite is now happening," end quote. In fact, this came on top of the ongoing entry ban of international media to report freely from inside Gaza at a time when also a number of senior UN officials are not given permission to visit Gaza and or are prevented to travel to the West Bank, including East Jerusalem. Among these senior UN officials is UN Secretary General Antonio Guterres, who was declared persona non grata by Israel on October 2, 2024, and banned from entering the country and effectively the OPT. The unilateral decision of the Israeli government to completely stop the transfer of humanitarian aid to Gaza as of March 2, 2025, constitutes a form of collective punishment against all civilians in Gaza. This action goes against Israel's obligations as the occupying power in Gaza, as outlined in the 4th Geneva Convention to ensure access to humanitarian assistance. This policy of collective punishment has been reconfirmed in a written statement issued on April 16, 2025 by the Minister of Defense of Israel, stating that the blockade on aid to Gaza will be maintained in order to exert pressure on Hamas to release the remaining hostages. Additionally, several Israeli ministers have reiterated their harsh rhetoric calling for the policy of no aid in Gaza until the release of hostages. The Israeli Knesset voted on February 19, 2025 to approve in a preliminary reading the amendments to the association's bill. The said amendment stipulates that organizations receiving any funding from foreign entities and are not budgeted by the State of Israel will be subject to an 80% tax on every donation received from such a foreign source. The draft bill essentially aims to cut international donations destined for Palestinians in the OPT. The Israeli failure to implement its international obligations has been most flagrant in its long-time targeting of UNRWA and its public services to Palestinian refugees. The agency was established through UNRWA Resolution 3024 in 1949 as a subsidiary UN body tasked with providing essential services and humanitarian assistance to Palestinian refugees across its operational territories, including the OPT encompassing East Jerusalem. Following the 1967 conflict, Israeli authorities formally requested UNRWA's continued presence in these territories through a Comey-Michel-Moore agreement. Despite its critical humanitarian role, UNRWA has faced significant challenges due to Israeli policies and actions that have hindered its operations. These include movement restrictions on UNRWA personnel, arbitrary arrests, military operations targeting UN facilities, and the blockade on Gaza. UNRWA has documented incidents where Israeli forces have violated the agency's neutrality and inviolability, including attacks on its facilities and personnel. For example, in 2009, Israel bombed UNRWA's compound in Gaza, destroying humanitarian supplies. In 2013, an UNRWA staff member was killed by Israeli forces in the West Bank. According to OCHA, as of April 15, 2025, at least 417 aid workers, including 294 UN staff, have been killed. These, combined with Israel's approach toward UNRWA since the events of October 7th, represent an unprecedented attack to the immunity and privileges of the UN and severely restrict humanitarian aid to Gaza and the West Bank. Furthermore, these actions violate multiple international legal instruments, including the Fourth Geneva Convention, which obliges an occupying power to ensure humanitarian assistance and basic services to the civilian population. The ICJ has also issued provisional measures requiring Israel to allow humanitarian aid into Gaza, which Israel's actions directly undermine. Regarding the situation in Gaza, Israel's legislative actions further violate the three sets of provisional measures ordered by the ICJ in the case of South Africa versus Israel, January 26, March 28, and May 24, 2024. The said orders specifically required Israel to desist from actions creating conditions calculated to bring about the physical destruction of the protected Palestinian population and to facilitate unfettered humanitarian assistance to Gaza. The prohibition of UNRWA operations in Gaza, given the agency's status as the primary provider of humanitarian assistance to the civilian population, is a violation of the provisional measures and a conduct potentially constituting the destruction of Palestinians as a protected group. UNGA Resolution 7678 and the previous resolutions have condemned attacks on UNRWA facilities and reaffirmed the inviolability of UN premises. The Security Council has also passed resolutions urging Israel to respect international law and ensure humanitarian access. Furthermore, the UN Secretary General has reiterated Israel's obligations under the 1946 General Convention on Privileges and Immunities, emphasizing that UNRWA's operations must be protected. While barring UNRWA operations, Israel has failed to provide any alternative humanitarian mechanism for the 2.4 million Palestinian refugees in the OPT. Under Article 55 of the Fourth Geneva Convention, Israel is legally bound to ensure access to food, water and medical care. However, reports from the international bodies, including the UN Human Rights Council and the Independent International Commission of Inquiry, document systematic Israeli violations of these obligations. The killing of a Turkish-American national, Ayşenur Ezgi Eygi, in the occupied West Bank during peaceful protests further highlighted the grave risks faced by humanitarian aid volunteers in the OPT. Mr. President, distinguished members of the Court, today we appear before the ICJ to make a plea for justice, which in this case means peace and security for both Palestinians and Israelis. We seek to remain within the boundaries of the questions posed by the Court by UNGA. It is of grave concern that since the submission of our written statement in late February, Israeli aggression has once again flared up. According to UNRWA, since the collapse of the ceasefire in Gaza following the Israeli aerial strikes in Gaza on the night of March 17th and 18th, 2025, intense military activities and assaults have continued, killing and injuring hundreds of people and further damaging and destroying what remains as civilian infrastructure, including hospitals. Over 180 children were reported killed on March 18th, marking one of the highest single-day child death toll over the last year, according to UNICEF. On March 19th, 2 UN guest houses were hit in Deir el-Bala in Gaza middle areas, killing 1 team member of the UN ops and injuring 6 more UN staff, some of whom sustained life-altering injuries. Humanitarian aid and supplies have not entered the Gaza Strip since March 2nd, when the Israeli authorities reimposed the siege. This siege has now lasted over 8 weeks, surpassing the duration of the total siege imposed in October 2023, when hostilities first started. As a result, critical humanitarian supplies, including food and medical aid, have been rapidly depleting. Israel's imposed restrictions on aid delivery to Gaza, which have proven particularly deadly for children, could have been prevented had UNRWA maintained its full operations throughout Gaza and the occupied Palestinian territories. In the West Bank, large-scale operations of the Israeli forces that started in the Jenin camp and other areas in the north on January 21st is ongoing, making it by far the single longest operation of the Israeli forces in the West Bank since the Second Intifada and causing the largest population displacement since the 1967 war. Against this backdrop, two developments are particularly concerning for the ICJ's mandate to provide an advisory opinion. First, due to the unbearable Israeli attacks on Gaza, which also target UN humanitarian workers, the UN Secretary General has taken the difficult decision to reduce the organization's footprint in Gaza. This is a blow to international efforts to restore Israel's international obligations in the OPT. Second, on March 23, 2025, 8 Palestinian medics, along with 6 civil defense first responders and a UN staff member, were killed by Israeli forces in southern Gaza. 5 ambulances, a fire truck, and a UN vehicle were struck one by one in the El Hashashin area, and their bodies were recovered from a mass grave. Even worse, the preliminary investigations point to deliberate executions at point blank. This was yet another instance of Israel's deliberate attack on humanitarian aid workers and UN personnel. Humanitarian organizations demanded accountability, calling the attack a war crime. The UN and aid groups have urged an investigation, emphasizing the protection of medics in conflict zones. Turkey is deeply concerned about Israel's persistent non-compliance with its obligations under international law. On top of its incessant crimes against the Palestinian people, Israel's obstruction of humanitarian aid, targeting of UN facilities, and harassment of UN personnel not only exacerbate the suffering of the Palestinian people, but also compromise the rule-based multilateral system, undermines the credibility of the international legal order, and seriously weaken the effectiveness of international bodies such as the UN and legal instruments such as the Fourth Geneva Convention. Such actions must be addressed by the international community urgently to ensure accountability and justice. Therefore, Turkey respectfully requests the ICJ to issue an advisory opinion that reaffirms Israel's obligations under international law, paves the way for taking measures to prevent further violations of these obligations, and underscores the importance of respecting the presence and activities of the UN, other international organizations, and third states in the OPT. This court bears a legal, historical, and moral responsibility to reaffirm Israel's obligations under international law and the illegality of actions taken against the UN and its agencies, including UNRWA and other international organizations. Turkey shall remain fully committed to supporting a just and lasting solution to the Israeli-Palestinian conflict. Thank you.
I thank the representative of Turkey for his presentation. I now invite the next participating delegation, the Islamic Republic of Iran, to address the court. And I call upon His Excellency, Mr. Kazem Garibabadi, to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court. It is indeed an honor to appear before you on behalf of the Islamic Republic of Iran. The Holy Quran says, من أجل ذلك كتبنا على بني إسرائيل أنه من قتل نفسا بغير نفس أو فساد في الأرض فكأنما قتل الناس جميعا ومن أحياها فكأنما أحيا الناس جميعا. That is why we decreed for the children of Israel that whoever kills a soul without its being guilty of manslaughter or corruption on the earth is as though he had killed all mankind, and whoever saves a life is as though he had saved all mankind. As the principal judicial organ of the United Nations, this honorable court is once again called upon to address fundamental yet persistently overlooked rights of the Palestinian people. These include the right to urgently needed supplies essential to their survival, as well as of basic services and humanitarian and development assistance, the right to humanitarian access and basic necessities of life as referred to the question put to the court as per General Assembly Resolution of 19th December 2024. However, as we do not deem the Israeli occupying regime a legitimate member of the United Nations due to the illegality of its formation, we focus on violations of the Israeli regime in light of its prolonged occupation of Palestine and ongoing genocide, particularly in Gaza. As a preliminary remark, given Article 96 of the United Nations Charter, Para 1 of Article 65 of the Statute of the Court, and the Court's jurisprudence, we submit that the jurisdiction of the Court is evident and that there are no compelling reasons for the Court not to exercise its jurisdiction. Mr. President, it is too late. All the evidence points unequivocally to genocide. The window, if any, to stop the ongoing genocide in Gaza is rapidly closing. The question before the Court does not concern an ordinary armed conflict. It deals with a genocidal situation, and as such, it requires a response to address its specific circumstances. The Court has already decided in its orders of provisional measures more than 1 year ago that the Israeli occupying regime must, among others, I quote, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, end quote, and to take, I quote, all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provision at a scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene, and sanitation requirements, as well as the medical supplies, end quote. 1 year past the prolonged recalcitrance of the genocide and inaction of the international community at this juncture constitutes an absolute moral and legal failure. According to latest reports, around 52,000 Palestinians have been killed as martyrs and over 123,000 wounded since October 2023, a toll that rises daily and a direct result of pursuing the declared policy of dehumanization by the Israeli occupying regime. These are not mere numbers. They represent innocent children, women, the elderly, and families. An entire nation under siege, being systematically decimated. As these proceedings unfold, OCHA reports that no aid has entered Gaza since 2nd of March. Medical supplies are rapidly depleting, including critical stocks for maternal and child health, as the number of aid workers killed since October 2023 has reached 412. Meanwhile, UNRWA and other humanitarian actors face systematic obstruction in delivering aid. The disaster is currently so frustrating that on 7th April, the heads of OCHA, the UNICEF, the United Nations Office for Project Services, UNRWA, WFP, WHO, and IOM issued an urgent appeal to world leaders to act firmly and urgently to save Palestinians in Gaza, with a high-level United Nations official says that, I quote, "We are being deliberately blocked from saving lives in Gaza, and so civilians are dying," end quote. How much more must the world witness before recognizing the genocidal intent behind these atrocities, including the infliction of severe bodily and mental harm, the deliberate imposition of conditions calculated to bring about Palestinians' physical destruction? All the aforementioned is just a fraction of the decades-long Israeli regime's crimes in Palestine. Dozens of United Nations resolutions, reports, and decisions, alongside the dicta of this court in numerous advisory and contentious proceedings, have affirmed the illegality of occupation and the imperative of unimpeded humanitarian access. Yet these rulings and appeals have gone unheeded, as inhuman acts persist with devastating consequences. This totality of actions has, in our view, created a sui generis situation, demanding an equally sui generis response, specifically tailored to end the prolonged occupation, stop the genocide, save lives, secure the right to self-determination of Palestinians, and bring criminals to justice. Mr. President, members of the court, in our oral statement today, we submit that obstruction of humanitarian aid constitutes a violation of international humanitarian law. It further violates Palestinians' fundamental rights. Commission of international crimes both contribute to and result from obstruction of humanitarian access. And we finally submit that the United Nations, other international organizations, and third states are under an obligation to ensure Palestinians' access to humanitarian aid. Meanwhile, given the unprecedented gravity of the ongoing genocide, our arguments will demonstrate a clear nexus between obstruction of humanitarian aid and its human consequences, and the international community's obligation to prevent genocide. Mr. President, members of the court, as an occupying power, the Israeli occupying regime has systematically and repeatedly obstructed access to civilian population in flagrant violation of international humanitarian law, including provisions of the Hague Regulations 1907, as well as the Fourth Geneva Convention of 1949. Article 43 of the Hague Regulations, as well as Articles 23, 33, 47, 50, 53, 55, and 56 of the Fourth Geneva Convention unequivocally account for the obligations of the Israeli occupying regime, including to cooperate with the United Nations, its agencies and bodies, other international organizations, and third states to ensure Palestinians' access to urgently needed supplies essential to their survival. Among these provisions, Article 43 of the Hague Regulations is particularly pertinent, expressly requiring the occupying power to, and I quote, take all measures in its power to restore and ensure, as far as possible, public order and safety of the occupied territory, end quote. Moreover, Article 55 of the Fourth Geneva Convention is explicit in obliging the occupying power to ensure the food and medical supplies of the civilian population. Mr. President, members of the court, the Palestinian people in Gaza and the West Bank in particular have been deprived of the basic necessities essential to their survival, leading to violation of their fundamental human rights to life, water, food, and health, among others. First and foremost, right to life, especially in Gaza, has become a mirage. Killing is occurring on a daily basis. The threshold under Article 2 of the Genocide Convention was crossed a long time ago. With deliberate targeting of civilians, all belonging to a group, as well as the deliberate obstruction of humanitarian and vital for their survival, genocidal intent is beyond evident. Apart from direct death, what has been underreported is indirect death that add significantly to the gravity of the situation, in particular in Gaza. According to a recent study, deaths due to traumatic injury in the Gaza Strip between 7th October 2023 and 30th of June 2024 reflect an exceptionally high mortality rate, underscoring the urgent need for interventions to prevent further loss of life. Concerning violation of Palestinians' right to water as a result of blocking humanitarian access, apart from a scarcity of clean, fresh water in Gaza for more than a decade due to destruction of water and sanitation infrastructure, in October 2023, the Israeli occupying regime closed the water pipelines into Gaza and cut off the electricity needed to run the desalination plants that process the brackish water that flows from the coastal aquifer. According to WHO, poor access to fresh water has resulted in water-related diseases such as hepatitis A, which is typically acquired by consuming contaminated food or water. What has deteriorated the water tragedy in Gaza, specifically during the past year, has been the brutal devastation of United Nations structure for water, sanitation, and hygiene in the Gaza Strip, demonstrating the Israeli occupying regime's direct targeting of humanitarian aid from the United Nations, even prior to recent years' strikes. The question remains as to how this cannot be seen as evidence of genocidal intent by the Israeli occupying regime. As regards Palestinians' right to food, the OCHA announced in November 2023 already that Gazans were at a high risk of starvation, further stating that it was incapable of providing adequate food, water, and medical care to meet Gazans' needs. As another example, as early as March 2024, a report was released by the Integrated Food Security Phase Classification Famine Review Committee, stating that widespread famine would be imminent in Gaza, and there would be, I quote, a major acceleration of death and malnutrition, end quote. Mr. President, members of the court, more than a year has passed since this catastrophic phase, and the situation has only deteriorated as starvation and willful obstruction of humanitarian aid causes serious bodily harm to Palestinians, again in contravention of the Genocide Convention. Mr. President, members of the court, Gaza's health system has also been debilitated by the Israeli regime. At least 627 healthcare workers are known to have been killed, 212 have been arrested, and 47 ambulances have been destroyed or damaged through targeted attacks. By January 2024, the Israeli regime had already bombed every one of Gaza's 12 universities in what may be called a full-fledged scholaticide, ironically, at a time when the need for doctors has never been so urgent. No medical student has been able to graduate. What is even more staggering is the often neglected psychological effects of the Israeli regime's actions on the well-being of civilians in Palestine, and in particular in Gaza. Years of exposure to violence, displacement, and loss have led to a burgeoning mental health crisis with chronic stress, PTSD, depression, and anxiety becoming endemic, living in the Gazan children particularly vulnerable. The impact of this psychological trauma is profound. In such a crisis, blockade of access to medical care of the United Nations, other international organizations and entities is a blatant disregard for fundamental principles of international law by the Israeli occupying regime, significantly undermining the Palestinians' right to health. This constitutes a literal violation of Article 2 of the Genocide Convention, as its terms are breached verbatim by the Israeli occupying regime. Mr. President, distinguished members of the court, international crimes being committed by the Israeli occupying regime in Palestine have appeared as a cause and effect of obstruction of humanitarian access. These include, among others, genocide, war crimes, and crimes against humanity. This pattern is reflected in the ICC prosecutor's application for arrest warrants against Israeli criminals and the pending proceedings before this honorable court regarding alleged violations of the Genocide Convention. War crimes have become a routine by the Israeli occupying regime, particularly in Gaza Strip. Attacks against civilians, including United Nations staff, medical personnel, as well as journalists, deliberate targeting of civilian infrastructure and medical facilities, and imposing collective punishment on the civilian population are only part of the war crimes committed by the Israeli occupying regime in the last year. According to the United Nations, up to 1.9 million people in Gaza are internally displaced, including people who have been displaced 9 or 10 times. From the perspective of displacement, the present-day ethnic cleansing of Gaza can be compared to the 1948 Nakba of Palestine. This, among others, is a clear instance of crimes against humanity, especially when coupled with obstruction of humanitarian access. More concerning still is the estimate provided by the United Nations and other organizations about increasing numbers of newborns on brink of death. The United Nations highlighted hunger, starvation, and famine as the cause of such deaths as a result of extensive restrictions by the Israeli regime on the entry and distribution of humanitarian aid and commercial goods, mass population displacement, and the destruction of crucial civilian infrastructure. Such measures are intended to prevent births among Palestinians as an instance of genocide under Article 2 of the Genocide Convention. According to another report by the United Nations Independent International Commission of Inquiry in Palestine, the Israeli regime has perpetrated a concerted policy to destroy Gaza's healthcare system as part of a broader assault in Gaza, which is evidence of commission of the crime against humanity of extermination. Such policies and practices have systematically denied humanitarian access to United Nations agencies and other relief organizations, precluding the delivery of vital assistance to civilians, a pattern appearing both as a cause and effect of obstruction of humanitarian access. Mr. President, members of the court, to conclude, the question put to the court on its face concerns humanitarian access to a civilian population. In a situation of armed conflict, however, we are faced with a genocidal situation here. It is indispensable for the court to opine on humanitarian access to a people targeted by genocidal acts and the ensuing obligations of the international community to stop them. In its judgment of 26 February 2007 in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina versus Serbia and Montenegro, the court clarified the content of the duty to prevent genocide under the Convention. In the court's opinion, responsibility is incurred, I quote, if the state manifestly failed to take all measures to prevent genocide which were within its power and which might have contributed to preventing the genocide, end quote. The court further considers the first parameter to be, I quote, the capacity to influence effectively the action of persons likely to commit or already committing genocide, end quote. In the court's view, I quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of or should normally have learned of the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing genocide, or reasonably suspected of harboring a specific intent, it is under a duty to make such use of these means as the circumstances permit, end quote. Mr. President, we ask if there is a state that has not learned of the existence of a serious risk that genocide would be committed in Gaza. What have those states that are in a position to prevent genocide done to fulfill their duty under the Convention? We regard obstruction of humanitarian aid by the Israeli occupying regime as, among others, evidence of genocidal intent and invite the court to clarify a state's duties to ensure Palestinians' humanitarian access in view of a state's obligation to prevent genocide under the Genocide Convention. Having said that, notwithstanding the present proceedings, the rules are clear. Obligations of states and international organizations are evident, and the international community has again failed. This is the failure of the United Nations system, the United Nations member states, and that of humanity. This failure has already been registered in the archives of human history due to and because of supremacy of politics over rule of law. Lastly, this statement shall in no way imply our recognition of the Israeli regime. I thank you, Mr. President.
I thank the representative of the Islamic Republic of Iran for his presentation. J'invite à présent la délégation de la Jordanie à prendre la parole et appelle à la barre le professeur Marcel Cohen. Monsieur, je vous en prie.
Monsieur le Président, Mesdames et Messieurs les juges, c'est un honneur de comparaître devant vous au nom du Royaume hachémite de Jordanie et de ratifier son exposé écrit et ses conclusions où nous dressons la liste de toutes les obligations d'Israël qui font l'objet de la présente demande d'avis consultatif. La Jordanie est particulièrement concernée par les questions qui sont débattues ici. Le Royaume hachémite accueille sur son territoire 2 400 000 réfugiés palestiniens enregistrés par l'UNRWA. Il est le gardien des lieux saints musulmans et chrétiens de Jérusalem et se trouve en première ligne dans la fourniture d'aide humanitaire à la population du territoire palestinien occupé. La Jordanie entretient des relations diplomatiques aussi bien avec l'État d'Israël qu'avec l'État de Palestine et ouvre sans relâche pour la paix au Moyen-Orient. Après le dépôt des exposés écrits, la situation s'est dramatiquement aggravée. Comme conséquence de la rupture du cessez-le-feu, l'interdiction de l'assistance humanitaire à Gaza et les actions israéliennes en Cisjordanie, d'où l'importance et l'urgence de cet avis consultatif. Je vais brièvement aborder la question de l'exercice par votre cours de la compétence consultative et examiner ensuite l'impact du principe d'autodétermination sur les différents aspects de la question posée par l'Assemblée générale. Mes collègues Eric Björge et Alfredo Crossato aborderont respectivement les droits de l'ONU et l'assistance humanitaire. Monsieur le Président, il existe des raisons décisives pour que la Cour exerce sa compétence consultative. Les Nations unies ont une responsabilité permanente concernant la question palestinienne jusqu'à ce que tous ces aspects soient réglés en conformité au droit international. Les arguments avancés contre l'exercice de votre compétence ne sont pas fondés, à savoir, il existerait un risque de préjugement du fait de l'existence d'une affaire contentieuse pendante. 2. Que la question aurait déjà été traitée par la Cour dans son avis de 2024. 3. Que la question serait unidirectionnelle et éviterait de tenir compte du contexte. 4. que la Cour n'aurait pas les éléments de fait nécessaires. Il suffira de dire ici que l'affaire Afrique du Sud contre Israël concerne exclusivement la Convention sur le génocide, alors que la question posée ici a trait aux obligations d'Israël dans un cadre plus général. La question diffère aussi de celle déjà répondue par la Cour en 2024. L'avis consultatif de l'an dernier fournit des éléments juridiques précieux pour mieux répondre à la question posée maintenant, qui n'a pas été soulevée par l'Assemblée générale dans sa demande précédente. Si la question se réfère uniquement aux obligations d'Israël, c'est parce que c'est cet État et pas d'autres qui occupent le territoire palestinien. La question posée a une portée limitée. Elle ne vise pas à aborder l'ensemble des questions liées à la persistance de l'occupation ou à la situation découlant du 7 octobre 2023. L'Assemblée générale, tout comme le Conseil de sécurité et votre propre Cour, ont déjà exigé la libération immédiate et inconditionnelle des otages détenus à Gaza. Cette situation ne décharge pas Israël du respect de ses obligations en vertu du droit international. Par ailleurs, la question posée porte sur les obligations juridiques et la Cour possède les éléments de fait lui permettant de s'y prononcer. Si Israël a des griefs contre les Nations unies ou ses organes, la Convention sur les privilèges et les immunités des Nations unies lui donne les moyens nécessaires pour y recourir. Monsieur le Président, Mesdames et Messieurs les juges, les principes d'autodétermination revêtent une importance capitale pour répondre à chacun des éléments de la question posée. En effet, le respect et la mise en œuvre de ces droits par le peuple palestinien est la toile de fond à partir de laquelle toutes les autres obligations incombant à Israël doivent être interprétées et appliquées. Il exige en outre qu'Israël, dans les circonstances actuelles et conformément à son obligation de ne pas entraver la réalisation de ce droit, adopte toutes les mesures nécessaires et efficaces pour protéger la population civile palestinienne. Étant l'autodétermination un principe fondamental du droit international, un droit erga omnes et une règle impérative du droit international, les obligations d'Israël le sont non seulement à l'égard du peuple palestinien, mais aussi par rapport aux compétences des Nations unies en la matière et à la communauté internationale dans son ensemble. Comme le dit l'article 1er commun des deux pactes des droits humains, je cite, « En aucun cas, un peuple ne pourra être privé de ses propres moyens de subsistance. » Fin de citation. L'obligation de respecter les droits du peuple palestinien à disposer de lui-même n'admet de la part d'Israël aucune exception. Les pouvoirs que le règlement de la Haye et la Convention 4 de Genève reconnaissent à la puissance occupante ne peuvent pas être appliqués à l'encontre du droit impératif d'autodétermination. En temps de conflit armé, seules les règles relatives à la protection de la personne humaine ont été considérées par votre Cour comme des principes intransgressibles du droit international coutumier, et l'occupant doit les respecter. Comme la Cour l'a affirmé, les pouvoirs reconnus à la puissance occupante le sont pour une occupation temporaire, pas pour une occupation prolongée qui constitue de facto une annexion permanente en violation du principe d'autodétermination. Israël a l'obligation de coopérer avec les Nations unies, les autres organisations internationales et les États tiers pour mettre fin le plus rapidement possible à sa présence illicite dans le territoire palestinien occupé, afin de permettre le plein exercice du droit du peuple palestinien à l'autodétermination, de cesser toute activité qui empêche cet exercice et d'agir positivement pour les faciliter. Cela inclut l'obligation de respecter son intégrité territoriale, en empêchant toute forme de déplacement de ces composantes et en s'abstenant de tout changement de la composition démographique du territoire, en assurant et en facilitant la fourniture sans entrave des approvisionnements d'urgence essentiels à la survie de la population civile, ainsi que des services de base et de l'aide humanitaire et au développement. Israël a aussi l'obligation de respecter la souveraineté permanente du peuple palestinien sur ses richesses et ressources naturelles et ne pas entraver les relations diplomatiques, consulaires et autres des États tiers et des organisations internationales avec les autorités palestiniennes. La Knesset a adopté une déclaration indiquant qu'elle s'opposait à la création d'un État palestinien, et ce, un jour avant que votre Cour ne rende son avis consultatif en juillet 2024. Cette déclaration du Parlement israélien est à nouveau en contradiction flagrante avec les droits du peuple palestinien à l'autodétermination. Tous les organes de l'État d'Israël ont l'obligation de respecter ces droits et de ne pas faire obstacle à sa mise en œuvre. En ce sens, l'obligation existe d'abroger toute disposition législative ou administrative visant à empêcher la réalisation du droit à l'autodétermination. Monsieur le Président, Mesdames et Messieurs les juges, rien ne justifie le maintien de l'occupation israélienne sur le peuple palestinien qui l'empêche d'exercer son droit à l'autodétermination. La première obligation pertinente est donc celle de respecter ses droits et de cesser sa violation. C'est par le respect strict du droit international et non pas par l'expansionnisme, l'oppression ou la force que l'on peut régler les problèmes. La meilleure garantie pour la paix de tous les Moyen-Orient est la solution à deux États dans le respect de leur indépendance et de leur sécurité. Je vous remercie de votre attention et vous prie, Monsieur le Président, de donner la parole au professeur Eirik Bjørge.
Je remercie le professeur Cohen. I now invite Professor Eirik Bjørge to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of Jordan to address Israel's obligations under the law of the United Nations. I make 4 points. First, Israel's obligation to respect the privileges and immunities of the United Nations. Second, Israel's obligation to give the United Nations every assistance. Third, Israel's obligation to cooperate with other states. And fourth, Israel's obligations regarding the safety and security of United Nations personnel. First, Israel has an obligation to respect the privileges and immunities of the United Nations. Israel recognized in the exchange of letters with UNRWA of 1967 that a number of facilities were essential for the agency to operate effectively. The fact that Israel recognized these facilities as essential indicates that they are, pursuant to Article 105 of the Charter, necessary for the fulfillment of UNRWA's purposes. The General Assembly has recalled that the agency, as a subsidiary organ of the United Nations, enjoys the benefits of the Convention on the Privileges and Immunities of the United Nations. The main provisions of the General Convention anyway reflect customary international law. I will deal with 3 of these. The immunity from every form of legal process set forth in Section 2 is essential for the independent exercise by UNRWA of its functions. The inviolability of UNRWA premises set forth in Section 3 guarantees that the premises may not be entered and that the United Nations must itself be permitted to control activities occurring on those premises. All UNRWA officials enjoy immunity and the privileges set forth in Section 18. The provisions relating to officials in the General Convention apply to all staff members, the only exception being those recruited locally and assigned to hourly rates. Those criteria are cumulative. The immunity of UNRWA from every form of legal process and the inviolability of its premises are absolute. They may not be qualified or overridden by military expediency or national security. Israel has an absolute obligation to respect the privileges and immunities of the United Nations. Israel self-evidently has an obligation, inter alia, not to enter UNRWA premises, not to damage or destroy such premises, not to detain UNRWA staff without charge or trial, and not to seek to extirpate the agency from the occupied Palestinian territory. Second, the text of Article 2, Paragraph 5 of the Charter is to the effect that Israel has a general obligation to give every assistance to the United Nations. State practice, including that of Israel itself, confirms this. The contention by Israel that the obligation relates only to enforcement action taken by the Security Council has no basis in international law. The interpretation for which Israel now contends runs counter to the clear wording of Article 2(5) and is inconsistent with the court's interpretation in the reparations case. Israel has an obligation to give UNRWA every assistance in any action it takes pursuant to the provisions of the Charter. There is a further aspect. Judge Lauterpacht was correct in voting procedure, where he observed that a state which ignores a series of General Assembly resolutions acts at its peril when a point is reached, when the cumulative effect of the persistent disregard of the articulate opinion of the organization is such as to foster the conviction that the state in question has become guilty of disloyalty to the principles and purposes of the Charter. Israel is obliged to give the Charter, Israel is obliged under the Charter to give due consideration in good faith to the resolutions of the General Assembly. In whaling in the Antarctic, the court adopted this reasoning in respect of the Whaling Convention. It applies no less to the Charter. Israel has the obligation to give due regard to General Assembly resolutions, notably those adopted in the 10th Emergency Special Session.